once the motorist is arrested, and they are then required, the police officer is then required under 11501.1c to read verbatim the implied consent warning to motorists. Keep in mind that if this arrest is on private property, the police officer is not required to give the warning to motorists. In that case, the police officer could immediately go to the request for a breath, blood, or urine. However, if it is on a public highway, they're either actually driving on a public highway or public maintained lot, or they are in fact, and then they are in physical control and they're arrested, the police officer is required to warn the motorist that their license suspension will occur if they refuse to submit to a chemical test or tests that show a .08 or greater, or any amount of drug, substance, intoxicating compounds, consumption of cannabis, a controlled substance, an intoxicating compound under the use of intoxicating compounds, or methamphetamine. The police officer has a warning to motorists form, a standard warning to motorists form that every police officer should have in the state of Illinois, and they in fact will use the same form. They must read it verbatim. And normally what police officers will do is read it verbatim in that they will give a copy to the motorist to follow along. And this warning to motorists must include information regarding the periods of suspension that to occur under 6-208.1. Once the arresting officer has read it verbatim, then they will fill out the bottom, and we will look at it in a minute with the date, the time, the officer's signature, and then the officer, along with a packet of the tickets and the notice of summary suspension, will give a copy to the court of venue, and will give a copy to the motorist, and the officer will then keep a third copy. Case law is clear that the oral warnings, as long as they are verbatim, are sufficient. Written warnings are not required under the Rakers case. It is important, though, that the officer reads them verbatim. Now, on the warning to motorists, there are certain provisions that if they do not apply, the officer is not required to read. For example, if the motorist is not under the age of 21, the officer is not required to read that. Rather, the officer could strike that entire provision of motorist under 21 and initial it. If the motorist is not a school bus driver, whether on duty or off duty, the officer could then in fact strike that area, initial it, and not read that. If the individual is not does not hold a commercial driver's license, and again, the law in Illinois applies to an individual with a commercial driver's license whether they are in their commercial motor vehicle or not. So however, if they're not a commercial motor vehicle and do not hold what we call CDL, the officer is not required to read that. So they can strike that, literally strike through it, and initial it. If in fact, though, the motorist does hold a commercial driver's license and they're off duty, the officer is required to do that. Miranda warnings are not required during the warning to motorist process, and they should not be read prior to the warning to motorist being read and a determination as to whether or not the motorist in fact will take a breath, blood, or urine. There's a doctrine called confusion, and what happens is if the officer reads the individual's rights, Miranda rights first, saying you have the right to remain silent, anything say can be used against you in the court of law, the motorist may be confused and say, well, I'm not going to answer at all, when in fact they are requested by the police officer to read or to take a blood, breath, or urine. So it's suggested, strongly suggested, based on the doctrine of confusion that the appellate courts have referred to, is that the warning to motorist provision is read first and that the police officer makes a determination as to whether or not, in fact, the motorist is going to take a breath test. From the defense standpoint, if the defendant says, well, you know, I think I'll wait until I get home and maybe I'll make a decision, or if the sun comes up, or I want to talk to my lawyer, those are not valid reasons in which to delay the warning to motorist. At that point, the motorist must in fact give an answer. A motorist's lack of answer or a conditional answer, the police officer can treat it as the motorist is not going to comply and give a breath, blood, or urine and treat it as a refusal. Silence is another issue where the defense attorneys will raise if the motorist is silent, what do we do? And I think it's incumbent upon the police officer at that point, in fact, to ask, are you going to take a test? If you don't give me an answer, I'm in fact going to treat this as a refusal.